Good morning all. I think there was some miscommunication in the timings. I had actually told them 8:30, but I think they have put it as 9 o'clock again. Well, they have not updated. I was actually informed them 8:30. Even I got to know in the morning that they have mentioned it as 9 o'clock. So I thought, fine. Sorry for the miscommunication or lack of communication. ಇದೆ ಬಿಡು. So okay, so let's discuss preamble now. Again, preamble is a kind of a favorite topic for UPSC. I think 25 was the only year in the last 5-6 years you can say where they did not ask a question on preamble. Maybe 24 also they did not ask, but for almost 5-6 years regularly they have asked questions on preamble one or other way, and very easy to handle also, except one or two kind of a conceptually they try to kind of make it a little tricky. Other than that, easily you can handle. Fine, of course the core conceptual itself. So current affairs angle is a little less here, but of course as I told you, remember that Subramanian Swamy had put education Balram Singh case in which Supreme Court did not say anything new. They told that the word socialist and secular, let it continue. I'm sure there is nothing new, not a landmark judgment also. Multiple times I have told it, they again repeated the same. Fine, because Subramanian Swamy and some other petitioner had requested that. I think yesterday I told you that. So that delete those terms or at least change the date. How can you still retain the date as November 26, 1949? And because on that day the term socialist and secular were not there, either delete those words or change the name. I mean, change the date was his request. Supreme Court so you need not interpret constitution so rigidly. So let's interpret it more broadly. So let it continue. There is no harm in it, and they have already clarified it multiple times that Indian socialism you should not confuse with which one, the Marxian socialism or the word communist kind of a one. It's a what you obviously be, as we keep telling multiple times, democratic socialism. It's based on egalitarian concept, all those ones. That's why let it continue. Secularism also Supreme Court has told multiple times that it's already what part of basic structure also SR Bommai case. Fine, okay, whatever. All those will sum up quickly. Yeah, preamble. Just to mention descriptions because 1 year that has that question also. This obviously we keep mentioning in your normal class also. Please quickly keep noting it down. Concept of preamble in simple terms borrowed from where? US. According to Palkewala, one of the very famous Supreme Court advocates of India, identity card of constitution. K.M. Munshi, horoscope of Sovereign Democratic Republic of India. Horoscope of Sovereign Democratic Republic of India. Pandit Thakur Das Bhargava. Precious jewel of constitution. Sir Ernest Barker. Keynote to the constitution. Keynote to the constitution. Then Justice Hidayatullah. If you recall Justice Hidayatullah, we keep mentioning in your cooling off period concept in judiciary, soul of the constitution. Even Pandit Thakur Das Bhargava also uses the term soul, but you can mention to him. Justice Hidayatullah, soul of the constitution. Justice Hidayat Ullah, soul of the Constitution. Yeah, so he had also mentioned that word. So he had mentioned it as that it is soul as well as precious jewel. He had also mentioned this. So interchangeably you can use it. Fine, but this is not the famous ones. They had asked this question. When we go through PYQs, you'll get an idea. Very simple one, of course. Berubari Union case, 1960. What is Supreme Court described it as? Key to the minds of makers of Constitution. Then even this case once they had asked, LIC India case 1995. Preamble equals integral part of the Constitution. Preamble is an integral part of the Constitution. Then when you say preamble, first what do you get? Nature of Indian state, sovereign, socialist, secular, democratic, republic. 2. Goals, obviously you know, liberty, equality, fraternity, justice, etc. 5. Source of Constitution. Obviously, what is the source of Constitution? People of India. Then obviously date. Very simple, basics these are all. No current affairs angle, nothing here. Date of the adoption of Constitution, November 26, 1949. Fine? Yeah, 4 key aspects. And now just to understand, right, start from the first keyword. Only from prelims perspective, no need of examples and everything. Sovereignty in simple terms. Yesterday we have already mentioned it, free from any kind of external control. And when did India become sovereign? 26th Jan 1950. Unsure. That's it. Other than that, internal sovereignty, external sovereignty, all those are mains related. Those are all not necessary for here. There are lots of criticisms angle also, if you recall. Those are all part of your analysis part. From prelims perspective, there is more than enough. Fine. What do you mean by basic definition of sovereignty? When did India become sovereign? What are the criticisms? What are the types? Those are all your analytical prelims related, mains related part. So then, socialist. Yeah, first keyword, first point is what? Not mentioned in original constitution. Added by, of course, 42nd Amendment 1976. Understood? And what India follows? Democratic socialism to achieve egalitarianism. Democratic socialism to achieve egalitarianism. In simple terms, equal opportunities for all. Upliftment of vulnerable sections. That's it. Yeah, it's a gradual change in society. All of those things are there, but this is more than enough for prelims. And then obviously capitalism, socialism, communism, left, right, all those things are not necessary here. But obviously 1 year that asks that question. When you say communism, what is obviously the ultimate goal? Stateless, classless, because that 1 year that asks that question will go through that Karl Marx angle. Fine. For prelims angle, this is more than enough for. Yeah, then which one? Socialist, secular, same concept. Secular, first point is what? Again, not mentioned in origin 1950 constitution. Why? Reasons, that's again analytical part, not necessary in prelims. Not mentioned in 1950 constitution. Again same. Added by 42nd amendment 1976. Answered. Part SR Bommai case. Even recently also last year Supreme Court again clarified it. SR Bommai case, part of basic structure. Secularism, part of basic structure. Again, if you recall, actually in mains, positive secularism, negative secularism matters a lot. We'll just clarify it here. We'll not get into the details. Fine. Then other aspect, if you take the basic definition of secularism, what is it? No official religion for the state. No official religion for state. Fine. And then ours is what? Positives, just mention it. Negative secularism is where? West, more specifically France. What is it? Strict, just in same first keyword, strict separation between religion and state. Of course, there are details, everything for this. Between religion and state. Strict separation between religion and state. If you recall, no minority aspects, no special protections. So what you call state will not involve in any kind of religious issues. So many things are there, but the core point is strict separation between religion and state. Largely West. Ours is what? Positive secularism. India is the best example. Equal treatment and protection. Equal protection, treatment for all religions. Equal treatment and protection for all religions. Equal treatment and protection for all religions. Of course, we have what? Special protection for minorities. Government can interfere in religious issues. So government can manage religious activities like organizing Kumbh Mela, Mahamastakabhisheka, so many other things are there, or even typical Dasara kind of event also. All of these what? State can manage religious activities, religious events. Or HRC, Hindu Religious and Religious Endowments and Charities Department means what in Karnataka they call as Mujai Ilaka, where government itself will manage so many temples. Waqf boards are there, Hajj boards are there. So obviously in Punjab so many Gurdwaras will be managed, even wherever, so many states also. Those are all positive secularism. Understood? Equal treatment and protection for all religions. Principal distance from all religions. That kind of a one. So India follows positive secularism. Fine, that is another aspect. Yeah, basic structure is done. Fine, other things not necessary here. That's for your mains part. Then third is what? Democracy. Yeah, here again a little detailed. Democracy. Obviously, the moment you say democracy, what is the principle? Popular sovereignty. People are the ultimate decision makers. Popular sovereignty. Understood? Again, subdivide. Direct democracy. Means for largely you have 4 tools, which is what? That kind of question they have not asked, but just to keep it in mind. Initiative, recall, referendum, plebiscite. Understood? Initiative obviously is followed in India. Initiative means what, as the name says, you can initiate, people only can initiate certain, or people only can take certain decisions. That's initiative. Understood? In India, is that option allowed for people? Yes. Simple example is what? In Gram Sabha, people can decide development activities in their village. That is as simple as that. That is your initiative. Gram Sabha, people can decide their own development programs, is your initiative. What about recall? No right to recall in the constitution. Understood? So, because if in case that is a kind of your current affairs angle also, because last year also it was under discussion, not mentioned in the constitution. Which one? Right to recall. Recall means what? Obviously, as the name says, people will have the power to call back their representatives before they complete their term. And so in India it is not there, not mentioned in the constitution. In other words, not allowed for, not applicable for whom? Members of parliament or state legislature, MPs or MLAs or MLCs. First of all, MPs, Lok Sabha, MLA only directly elected, only them. But in general, it's not applicable for members of parliament or state legislature in India. But where is it applied to an extent? It is applicable for panchayats and municipalities to an extent. Again, not mentioned in the constitution. For panchayats, again for Gram Panchayat members, especially in states like Kerala, Uttar Pradesh, it is allowed. For municipalities in states like Madhya Pradesh and in some other states also, they are allowed it. But it is not allowed for MPs or MLAs or MLCs. Only for whom? Panchayats and municipality members, only in few states. That too not in entire country, not in 73rd Amendment, not in 74th Amendment. Only few states. Okay, that is right to recall. Referendum and plebiscite, both are common point. What is it? People will vote. People's vote on important issues. People's vote on issues is called as referendum and plebiscite. Referendum means what? On general matters. General matters means what? Do you want Aadhaar to be continued? Do you want one nation, one election to be followed? That kind of issues are referendums. Then what is plebiscite then? You are asking the people on territorial matters. Means what? Do you want to be part of India or do you want to secede from India? Understood? In India, both are not followed. No referendum, no plebiscite in India. In some other countries they do follow it, but in India, in Indian constitution, there is no reference to it. Yes, we also followed it to an extent. If you recall, when? Before constitution came into force. Example, if you recall, in Junagadh they had conducted a plebiscite. They asked the people of Junagadh, do you want to join India or do you want to join Pakistan? That's a plebiscite. Yesterday I told you where in Northwest Frontier Province, in Sylhet district of Assam, in British Balochistan, they had conducted plebiscite. Yes, before constitution. Under the constitution or after constitution came into force, no single referendum or plebiscite in India. Normally we don't follow that. Clear? So that's why, so don't even have to think or much worry about it. And which is the world's most famous direct democracy? Switzerland is world's most famous direct democracy. World's most famous is Switzerland. That kind of question they have not asked, but one question they have asked, if you see, we'll discuss that. So democracy means what always? Superiority or belief in the virtue of whom? Common man. Common man decides democracy. That's a simple question that asked. We'll go through that. That's very simple of democracy. And of course, obviously, I'll just sum up once for all. If you take components of democracy again, what do you have? Especially under indirect democracy. When you say indirect democracy, within that you subdivide it into three. Political. To this details, now in prelims normally chances are less, but just to clarify, three components are there: political, social and economic. If you only have political democracy in your country, you are called as what then? You are called as representative or electoral or procedural democracy. If all the three are there, then it is called as substantive or holistic or participatory or true democracy. What is political, social? Again, all those ones not necessary here. In simple terms, political means what? Political equality are there. Everybody can vote. Anybody can join. What do you call this? Contest election. Anybody can get to the top positions. Those are all political. Social means what? Absence of discrimination based on your social identities like religion, race, caste, those things. Economic means what then? Absence of discrimination based on economic class, which is what? Class, rich, poor, that kind of an absence of discrimination based on that. Or in other words, what do you call this? Prevention of concentration of wealth or income influence. That's also in a way economic democracy. So that's why what is largely the criticism in Indian context? That India is largely what kind of democracy? Political democracy, social and economic democracy. We are in the process. Yes, we have become largely a social and economic democracy also, but a lot of challenges still remain. That's why what a lot of people tell, India is a very successful electoral representative democracy, but we have moved towards substantive democracy yet to achieve the complete kind of a success. That is again means kind of a one that they can't ask it in your prelims saying, do you think India, that kind of a questions can't be expected in prelims, but just to keep it in mind. That's your democracy aspect. Fine. Then comes next keyword, republic. Very, very simple. Quickly finish off. What is the basic definition? Head of the state, that's it, directly or indirectly elected by people. Head of the state, directly or indirectly elected by people. That's very, very simple one. If you extend it, what it also says, absence of special privileges. Nobody will get special treatment. Absence of special privileges. I'm sure that's another word. In a way, another one is what? No hereditary public position. So public positions, you can't get it from your parents. Means what? The positions of prime ministers, MLAs, MP, whatever ministers, all those one, public positions are not hereditary. Private position is different. Means what? If your parents own a huge company, like let's say what you call from Dhirubhai Ambani, it came to Mukesh Ambani, from Mukesh it will go, that's different one, that we can't talk. Because that's a private issue that they can manage it on their own. And so public positions are not hereditary in a republic. Sure. Or in other words, if you want highest positions open for different words, they may ask highest public positions open for all. Highest public position is obviously who? President. Highest public position, different way, answer is the same, open for all. That is republic angle. But normally you recall that directly or indirectly elected by people, that's more than enough. Right? That's about your very simple aspects, sovereign, socialist, secular, democratic, republic. Now, let's start with equality. And sure, if you recall constitution, that is in preamble, what is mentioned? Equality of, exactly, equality of status and opportunity. These are the only two words mentioned in preamble. Equality of status and opportunity. But if you divide it a little, just to extend, of course, this concept is borrowed from where? Idea borrowed from France. If you divide it a little, because these are NCERT concepts, you never know, anytime they can ask. Till now they have not touched it. Equality of opportunity or equality of opportunity or formal equality. Understood? What does that mean? Focus is on what here? Equality on opportunity. Focus on means. Opposite. Equality of outcome or equality of outcome or substantive equality. Then what is the focus here? Focus on ends, goals. Simple example is what? Any affirmative action or affirmative actions like reservations. affirmative actions like reservations. Fine, they are all your equality of outcome, or what you call as substantive equality. Equality of outcome or substantive equality. Fine, focus on the goals or the ends. Again, what you have, political, social, economic, you can divide it also, but not necessary. Natural equality also is there. Those are all not listed. This is the core topic that you have to remember in your equality concept. Fine. Then comes your liberty. Unsure. Liberty of, recall, liberty of thought, expression, faith, belief, worship. Unsure. These are the 5 they mentioned. Of course, again same, which country? France. Again divided. Negative liberty, freedom from, in simple terms, absence of. Absence of external restrictions, restraints. That's your negative. Whatever is necessary, only for prelims we are discussing that. Positive liberty, freedom to, in other words, enhance the ability of an individual. Enhance the ability of an individual to realize his potential, ambition, goal. To realize his potential. To realize his potential ambitions. That is positive liberty. Understood? Now what is this negative liberty? Simplest definition of liberty. This is very simple definition. Now what is positive liberty then? Goal or real meaning. Understood? Most appropriate definition. You will see that this is the exact word they are used. Most appropriate definition, or you can say real goal, intention. Most appropriate definition of liberty. Most appropriate definition of liberty is what? Positive liberty, freedom to. That is a real goal. Most appropriate definition of liberty. Fine. Another one which they normally keep asking, which one? Liberty is what not? It is not absolute. In other words, what is it? It is qualified. In other words, what do you have? Reasonable restrictions. Understood? Yeah, that's why the famous statement, that also we will go through it, but you can copy that. There is no liberty if there are no laws. Or if there are no laws, if there are no laws, there is no liberty. No laws means you take it as if there are no reasonable restrictions, there is no liberty. Why is it? That's your famous statement. Why? Because what do you call this? You have one's liberty stops at the nose of other. Remember, we keep telling, that means everybody should use their liberty in a limited extent. If you use it beyond a limit, what will happen then? You will breach into, so you will get into someone else's freedom. So automatically everything will get violated. That's why only limited liberty will work in a society. Unlimited liberty will take the society out of control is the idea. Fine. If there are no laws, there is no liberty. Types of liberty and everything. Just to again understand, which one? This till now they have not asked, but in NCERT the concept is there. Even in normal class also I discussed this. Which one? Harm principle by J.S. Mill. In optionals they may discuss in detail also. First is what? Minor harm. In simple terms, no threat to life or property. Social disapproval is enough. Means society itself will handle it. No need to bring law, police, punishment, everything is not necessary. Social disapproval is enough, sufficient. Second comes what? Major harm. And that means opposite. Threats. Obviously what is it? Legal action necessary. So legal action means in simple terms, you need obviously some or other police action, punishments, jail sentences, courts, that kind of a one, major harm. So obviously the threat is always from which one? Major harm is a threat always. Fine. So major harm means threat to the life or property, legal action is necessary. Yeah, so two of many, I think at least 3 questions they have asked on this liberty. Fine. Yeah, then comes your next one, obviously, justice. Justice is from where? Former USSR. Here you have again 2 concepts, I mean, what do you call it? Political, economic, social justice. All 3 is mentioned in the preamble. Understood? And always remember, whenever you come across justice, you have to remember John Rawls. What he says, justice is fairness. And so theory of justice, John Rawls' theory of justice. It's again a very detailed one in optionals, but you just have to basic idea, you have to keep it in mind. What you call it as the original position, veil of ignorance, keywords if you remember. First two keywords, original position, veil of ignorance means you are asking few individuals to create a society without being biased to original position, veil of ignorance. Veil of ignorance means forget which community, which state, which religion you belong to, and then try to imagine what kind of society do you want. Obviously 2 principles, equality principle, difference principle. Again, to this extent normally in prelims they don't go, so no need to worry. Equality principle, difference principle. Within difference there are 2, all those ones are not necessary. Simple, maybe maximum they may ask who gave this concept of theory of justice. Keep it in mind, John Rawls. There is a concept of redistributive justice, all of those ones. But and in the constitution what kind of justice are mentioned? Political, social, economic. Any kind of affirmative action is based on the idea of justice. Here which on substantive equality is nothing but justice concept. Understood? Reservations in jobs, all of those ones, social justice. Economic justice is what again? What do you call this? In so many schemes, what do you call this? Extra provisions are provided for women will get easy credit. What do you call this? Physically challenged people will get easy credit. Minorities will get easy credits for to start their own businesses and everything. Those are all economic justice. Or government transferring Pradhan Mantri Krishi Samman Nidhi directly 6,000 rupees. Economic justice. Like that, so many are there. Those are all analytical part is not necessary here. That is justice angle. Then fraternity concept. First point, France. Just keywords. Second point, simple meaning brotherhood. Third point, to ensure dignity of an individual, thereby, because 1 year that asked this question also I think, unity and integrity of nation. So if they ask you what is the intention of fraternity, I think I am not sure if that asked or not. Even if they ask, don't choose unity and integrity, what is the intention? Dignity of an individual is the intention. So once you ensure that, then you can ensure what? Unity and integrity. So the intention of fraternity is not unity and integrity. What is the intention of fraternity? Dignity of an individual. So many provisions are there, like example, single citizenship, fundamental duties, even equality principle, all of them is this, single citizenship, fundamental duties, etc. All talk about fraternity. brotherhood. And remember, that's why without fraternity, what is not possible? That's why unity and integrity. If there is no fraternity, there is no concept of nation itself. Only if there is fraternity, nation state can exist. Or else nationalism, all those concepts itself will not be there. Fine? Okay, so that is one part. Then another simple part, obviously, just directly you write Berubari union case. Simple equation is what? Preamble not part of constitution. That's it. No need to write anything extra. Just reverse it. Keshwananda Bharati case. Preamble opposite. That's it. Part of constitution. The moment it is part of constitution, what is the next point? Can be amended. Of course, under which article then? 368. Of course, same, special majority. Obviously same. Next, what is it? Don't violate basic structure. Don't violate basic structure. Keshwananda Bharati case 1973. Preamble is part of constitution. It can be amended, special majority, but don't violate basic structure. Obviously, we all know how many times has it been amended? Only one time, 42nd amendment. Multiple times we have mentioned by now. 1976, which was socialist, secular and integrity, because it was earlier only unity of nation. Then they mentioned as what? Integrity of nation. Socialist, secular and integrity. Very simple ones, basics. Obviously in any foundation classes you would have already studied it. 42nd amendment 1976, socialist, secular and integrity added. Socialist, secular and integrity added. Fine. Another one, obviously what? In the Constituent Assembly, preamble was accepted as part of constitution. This normally chances are less to be asked as a question. In the Constituent Assembly, it was accepted as part of constitution. Then again, what Supreme Court has told? Preamble neither source of power, means preamble doesn't give you any extra power, or restrictions on powers of state. It is neither a source of power nor a restriction on the powers of state. 2, which is very famous one. What is preamble? Preamble is, so what Supreme Court has clarified is what? Preamble is non-justiciable. First point, non-justiciable means what? State not obligated to implement it. State not obligated to implement it. 2, one cannot go to courts. One cannot approach courts if it is not implemented. One cannot approach courts if it is not implemented. 3, courts cannot directly enforce it. Courts cannot directly enforce, implement it. Answered. Preamble is non-justiciable. Extension of this, what Supreme Court also clarified. Preamble can be indirectly implemented by implementing other parts of constitution. Indirectly implemented by implementing other parts of constitution. Simple is what? Yeah, that's it. Part 3, fundamental rights you implement. You achieve what? Equality, liberty. Part 4, DPSP you implement. You implement justice. Fundamental duties you implement fraternity. State is not obligated to implement it. One cannot approach courts if it is not implemented. Courts cannot directly enforce it. But preamble can be indirectly implemented by implementing other parts of constitution. Simple example, if fundamental rights are implemented, equality and liberty are implemented. If DPSP is implemented, justice is implemented. If fundamental duties are implemented, fraternity is implemented. So implement other parts, indirectly you can implement what? Preamble. Indirectly implemented by implementing other parts of constitution. Right? Yeah, so largely these are the points related to preamble. As I told, the only current affairs point is what? Balram Singh case, not a landmark case. Supreme Court again said, I have already told you that. Other than that, I don't think there is any current affairs angle involved in this. Let's directly go through very easy questions. They have linked it to other aspects also, but I think you can be able to easily understand. Economic justice as one of the objectives provided in. Of course, one is preamble, no doubt about it, and DPSP, because just now as I told, even at the end I was clarifying, justice concept means DPSP, welfare state concept means DPSP, keep that in mind. Like how parliamentary system means collective responsibility, federalism means division of power, constitutionalism means limited power, fundamental rights means equality and liberty, DPSP means justice, DPSP means welfare state, fundamental duties means fraternity, and so like that keywords. Okay, federalism, they have put it here. Actually they should have been put under, okay fine. So you can go through it. Obvious feature, not a feature they are telling. Yeah, yesterday we told, obviously two statements. One, because there is no agreement. Two, no right to secede. So those ones. Other are obviously features, we have mentioned it, independent judiciary, division of power, stay federate, okay, yeah, unequal representation in Rajya Sabha, fine. A simple application, that's it. Equality means absence of privileges, very, very simple ones. Minds of makers of constitution, preamble, which case? Berubari Union case. Democracy's superior virtue lies in the fact that always remember, democracy means popular sovereignty. So popular means what? Common man. Common man is the foundation for democracy. So wherever you find common man, just that is the answer always. Other things may be, may not be, that doesn't matter for us. And so that's why normally another principle is what? If there are two statements or three statements which are, what do you call this, which also looks like answer, what do you have to choose? Which is the most important, most closest, you have to choose that. Just now we mentioned, yeah, exactly, 5 keywords, liberty of thought, expression, faith, belief, worship. Very simple questions, these are all. Yeah, exact statement itself we wrote. But answer, if there are no laws, there is no liberty. Sir, what about other statements? Others may also be correct. For example, if you look at first statement, if there are more laws, there is less liberty. Actually, that is also correct. Because if you bring more laws, obviously what will happen? Restrictions will be more. Liberty will come down, no doubt about it. But the most apt answer is second statement. First statement we are not saying is wrong. Second statement is the most correct according to the whatever the demand of the question is there. Yeah, just now we wrote that again. Look at the word. Most appropriate definition of liberty is what? Most appropriate definition. Exactly. Opportunity to develop oneself fully. That means what? To whatever we had mentioned as what? Opportunity to what we had mentioned? If exactly to realize your potential, to realize your ambition, to your goals, they mention it as to develop yourself fully. Absence of restriction is what? Simplest definition of liberty. I think that question is also there. Yeah, preamble, yeah, just now whatever at the end we wrote. Which one? Whatever I told you just now, the T statement, but I had mentioned a different way. It can be indirectly implemented by implementing other parts of the constitution. In other words, it is part of the constitution, no legal effect independently of other parts. Independently of other parts means what? Indirect. If you implement that, you will implement this. They have told us no legal effect independently of other parts. Or you reverse it positively, right? It will have legal effect by being dependent on other parts. Understood? So if you want same statement, you copy, because if in case they repeat the statement, at least you should be where you just now wrote, it can be indirectly implemented by implementing other parts. Copy that fourth statement. Fine. So no legal effect independently of other parts. Actually, there was simplest definition question was also there. I think, okay, that's the easy one. Schedules were done. Yeah, so very easy aspects. Then comes your union and territories. Normally they don't ask too many questions from that, but let's finish it. Last year they had asked a question, if you recall, which one? Recall that 2025 prelims, 2025 only, I think Itanagar, Tripura. So Itanagar is the capital of whatever related to kind of match the following one. A little detail they had gone into. So normally they don't ask that kind of questions in this chapter, but that's what kind of a surprise element. Union and this territory, part 1, article 1 to article 4. Part 1, article 1 to article 4. Article 1, which is obvious, multiple times we have told, which is what? If they ask you first statement, the concept of union of states is borrowed from which country? Which country? As I yesterday also I clarified it. The concept is borrowed from, union of state concept is borrowed from Canada. Second statement, obviously I told you that according to Ambedkar we have already written it. Why have they used the term union of state? Just now we told, no agreement to, no right to secede. In short, that is what you call it as union of states. In simple terms, no agreement to, no rights to secede. Then very simple differences. Union of India means what? Only states. Territory of India, states plus UTs plus states plus union territories plus acquired territories. Understood? Now when you say acquired territories, what is it? At present, none. None, no union acquired territories as of today. Understood? Who can acquire it? By Government of India. What are the previous examples? Whatever, yeah, Goa, Daman, Diu, Dadra Nagar Haveli, Puducherry, Sikkim, all of them are your acquired territories in the past. At present, there is none. Understood? Then what is the next one then? What about how was it administered? Administered by or you can say administered similar to whom? Union territories. Administered similar to union territories. Administered similar to union territories. Administered similar to union territory. In other words, acquired territories are under whose control then? Government of India's control. Because in the constitution there are no details. If you want that clarity also mentioned. No details in the constitution. So they are not asked this kind of questions till now. No details in constitution with respect to its administration. Means how to administer, who will be there, will there be a legislature, no details are there in the constitution. In simple terms assume they are administered similar to union territories. Government of India will decide everything. Fine. That's the idea of your acquired territories. States plus UTs plus acquired territories. Of course there are different ways. You can either conquer, you can get it through agreement, you can get it through lease, you can get it through plebiscite, so many are there. But again, none of that clarity is there in the constitution. Those are all international law. Not necessary again, that's your article 1 simple. Then article 2, which is what? Parliament can, first one, admit into Union of India. Parliament can admit into Union of India already existing states. B. Establish new states that are not part of Union of India. Establish new states that are not part of Union of India. What are the examples? All those things is a little detailed one, but if in case you want that, example Sikkim, example Goa made state from UT in 1987. Establish new states that are not part of Union of India. Or if you make Delhi a state at whenever in the future, if in case they do it, that's your article 2 second provision. Establish new states that are not part of Union of India. A. Admit into Union of India already existing states. And all this power is only for whom? This is only and only for Parliament. And so just keep that in mind. So, but then which majority? All those ones. Same concept. What is it? That again we'll discuss again in article 4. Simple majority normal bill. That's it. That we'll discuss again. Article 3. More detailed, more important actually, which is what? In simple terms, Parliament can make any changes in Parliament can make any changes in the already existing parts of India. In short, what does that mean? A. Again, there is no kind of concept controversy. What is this? Current affairs angle, increase, decrease, or alter boundaries of states or UTs. B. Change the name of state or UT. C. Create a new state or UT either by dividing or merging states or UTs or parts of it. Anything. All of these is your Article 3. Create a new state or UT either by dividing or merging states or UTs or parts of it. So everything is related to your Article 3. Fine? Yeah, then related to that, what is it? Procedure. This is a very famous procedure. Procedure under Article 3. Very simply will sum up. A. President's prior recommendation required. Very theoretical, no current affairs angle. President's prior permission, prior recommendation required. President's prior recommendation required. B. Refer the bill to respective state legislature whose opinion not binding. Then pass the bill in Parliament by simple majority. Any further changes, no need to refer. Any further changes, no need to refer to states. And which is the ministry in charge of all these things? MHA in charge of all these things. MHA is in charge. But what if you want to change the name of a capital city or create a new district, taluka, all of those things, who will do it? States can do it on their own. And so there is no need. Of course, you may have to ask them. For example, recently, if you recall, what is this controversy was there with respect to Bangalore South District. Remember the Ramnagara, that kind of areas, they wanted to name that as Bangalore South. So Government of India did not agree there to an extent. You have to ask their opinion. And so because changing the names, you can't do it so easily because railways, everything you have to rename there. So Central Government of India will look into it. Most of the times they will approve it, but ultimate decision always is with whom here? Or ultimately, who will have to decide all this renaming of the districts, talukas, capital cities and everything? States. You just have to take the opinion of the center, but states is ultimate here. Judiciary as Supreme Court has clarified it multiple times. That is cities, districts, taluka kind of a one. But renaming of the state or union territory or anything, that is you have to whom? Article 3, Parliament. When Mysore state was named as Karnataka or Madras state renamed as Tamil Nadu, Parliament. So it is obviously multiple times we keep telling kind of current affairs what? Kerala wants to be renamed as Kerala, West Bengal wants to be renamed as Bengal or Bangla, whatever. Article 3, Parliament. So what is the states? Initiate a resolution, let them initiate or anything, let them do. Kerala also initiated it, that doesn't matter. Ultimately MHA has to approve. Then Cabinet, then Parliament, then President. Then President first prior recommendation, then Parliament pass it. Simple majority, ordinary bill. That's what is your next one, which is what? Just remember that very famous statement, just to mention. Normally they keep mentioning it. USA is famously called as what? US famously is called as indestructible union of indestructible states. India, just change the word. That's it. For India, change it as destructible states. That's a famous description. Indestructible union of indestructible states, indestructible union of destructible states. But normally on this chapter, relatively questions are very, very less. Except that 2025 they asked, That is a kind of a little geography, polity that kind of combined. History also kind of. Indestructible union of destructible states. India. US is indestructible, that's it. Fine, then Article 4. We say clarify, what is it? Any law passed under Article 2, 3 is not, what is it not? Constitutional amendment under Article 368. In other words, what is it? What is it passed by then? Passed by simple majority. In other words, it's passed by simple majority. And so that's the reason he called as what? Even though you make changes in which one? Remember, even though you make changes in first schedule and fourth schedule also, it is still not amendment to Constitution of 368. So multiple times they keep telling that, for example, you take Jammu Kashmir and Union word Ladakh, which was earlier the name of Ladakh itself was not mentioned because it was part of Jammu Kashmir. Earlier it was under name of where? Names of states it was there. Now if you look at Jammu Kashmir, it will be what? Under names of union territories. Ladakh is also under union territories. Actually you made changes to first schedule. Same way fourth schedule also. What you know is what? Allocation of Rajya Sabha seats. Earlier Jammu Kashmir will be under list of states. Now it will be under list of union territories. So actually you are making changes to first schedule and fourth schedule. Understood? But still what is it? Not an amendment to Constitution under 368. You should not consider it as. That's why you just call it as Jammu Kashmir Reorganization Act. You don't associate a number with it. Remember, as we normally keep telling, the simple logic is what? If there is a number associated, 106th amendment, all those things, that means it is amendment related to or amendment under. Yeah, number is there, it's related to 368. That means automatically which majority? Special majority. Number is not there, but still you are making changes to Constitution, that means simple majority. Not necessarily Article 3 or Article 2, but simple majority. Fine. Then three statements, Supreme Court's clarity. Again, till now they have not asked it, but just to mention. Which one? First is Berubari Union case. Government has no power to cede Indian territory to others. Government has no power to cede Indian territory to another country. Unsure. Then what is it? Only who can do it? Parliament can do it. That means how? Constitutional amendment under Article 368. Understood? Simple. The first famous example for that is what? 9th Constitutional Amendment 1960. Understood? Berubari Union. Larger percentage we got, whatever, few parts of it we have transferred it to then East Pakistan, that is today's Bangladesh. If you recall, normally we keep talking all of that, that's not necessary here. Nehru-Noon agreement. So directly Prime Ministers of India and Pakistan decide that we will share this Berubari Union territory. That's why Supreme Court clarified, neither PM nor President, nor everybody, government cannot take the decision by themselves. Who has to take the decision? Parliament has to take the decision. Amendment 368 special majority. That is one case. Second aspect is what? Second aspect, what do you call this? To resolve territorial conflicts, border disputes. To resolve border disputes, who can do it? Government can directly do it. To resolve boundary disputes, government can directly do it. This for this example is what? Example, again last time it was in news, Kachativu. Sure, Kachativu Island, between whom and whom? India and Sri Lanka, or Numur Island dispute between India and Bangladesh. Those are all your border disputes or boundary disputes. Directly government can do it. No need to what? amend the constitution or anything, because when you say boundary dispute, by definition, what does that mean? A territory which is for which there is no legal clarity about who has the control on it. That is called as boundary dispute. Understood? No legal clarity, no legal documents to show who has the control on it. That you call it as boundary dispute. Jammu, Kashmir, Aksai Chin, Arunachal Pradesh, these are all Sir Creek, they are all not boundary disputes. What are they? They are Indian territory illegally claimed by Pakistan and largely Pakistan, to an extent China. They are Indian territories. They are not boundary dispute. Jammu Kashmir is never a boundary dispute. It is integral part of India. For whom it can be boundary dispute? Pakistan can claim that it is a boundary dispute, but for us it is our integral part. They have illegally claimed part of whatever you call it as POK, China part of what you call the Aksai Chin area and all those ones. It should be clear in that boundary dispute means no legal clarity about who is its owner, who has the control on it. Kachativo, all of those. In the recent times again you don't have a new kind of a boundary dispute, all of those ones. But last year Kachativu was in news, obviously, as I told, if in case they go to kind of, because they make that kind of answer, they give you a historical angle to it. So Kachativu obviously signed between, India and Sri Lanka. Who gave the control? Indira Gandhi transferred it to Sri Lanka, but give and take approach. What we got? If you have heard, we got the control of what you call as this Dodge Bank, all those ones, which is very famous in, very rich in the fishing grounds. So India got access to it because actually Sri Lanka was controlling that area. We got control of it, but Kachativu, they got the control. But historically, that's a kind of a controversial angle also. At present, Kachativu is under Sri Lanka's control. Understood? Historically, if you look at it from almost 500,000 years, if you, almost 600 years, I think it's a volcanic island or something. So, in some part, some 50 or 100 years, Ramnath dynasty of Tamil Nadu had control, and then I think some 50 or 100 years, Sri Lankan, some other Sri Lankan empire had control on it. Then British Indian Empire got the control of it. From British India we got it, but Sri Lanka also was claiming it. It's a historically so much of confusions are there. That's why it's a dispute. India also agreed that. So yes, we take it as a dispute. If India had agreed that yes, that no, it is an integral part of India, then Indira Gandhi can't give up. Then what do you have to do? Indira Gandhi should have, or Parliament should have amended the constitution. To make it easy, she told, it's not an integral part, it's a dispute. It's kind of controversial also, that's why in a way, but whatever, during that time, whatever issues, in 1974, Indira Gandhi gave that control to Sri Lanka. Right? If in case they give a historical angle to it, so please keep that in mind. So that is another one. Of course, for this, we forgot another very basic, the most important one, which is what? 100th Constitutional Amendment 2015. What is it related to? Exactly. That I think that itself we forgot. Exchange of enclaves between India and Pakistan, India and which one? Bangladesh. 111 enclaves we gave up, 51 enclaves we got back. Again, what is enclave? All those ones not necessary here. Nobody will ask you that. It's not in current affairs also. In details, normally we discuss that. Actually, India lost the territory, more territory, but you can't help. You have to resolve. We had to resolve the dispute because it was continuing right from independence time, partition time to Indira Gandhi time. Continuously, it was there. So at least let's resolve it once for all. Fine. That is your 100th Constitutional Amendment 2015. That is your till Article 4. Then just to clear, very quickly sum up, which is what? Integration of princely states. Again, these are all again your basics, not a single question asked here. Integration of princely states. Obviously you all know, which is what, just simple, very quickly sum up. Indian Independence Act, or directly write 1947 Act. Princely states. Obviously what? Three options. What are they? Join India, join Pakistan, stay independent. When most of them joined, whichever were geographically within India, the controversial was what? Jammu and Kashmir, instrument of accession between Raja Hari Singh and Jawaharlal Nehru. Because of that only Article 370 got added. Then Hyderabad is what? Military action, though they call it as police action, army action, Operation Polo. Then Junagadh, as I've just now told, what they conducted there? Plebiscite. Though in books they mentioned it as referendum, plebiscite joined India. So that is only quickly princely states. Fine. Then they have not got to this depth, but if in case they go, Junagadh, plebiscite joined India. Quick. Then comes which one? 1950 Constitution. Part A. Former British provinces. Obviously, which is what? Madras, Bombay, Bengal, etc. So that is your Part A territories. Mentioned where? Mentioned in Part 6. Then Part B territories. Princely states with legislature. Of course, example, Mysore, Hyderabad, J&K, Travancore, etc. This is your Part 7, mentioned in Part 7 of the Constitution. Then Part C, other princely states plus chief commissioners provinces. Again, so many are there. Example, just one or two you write. Delhi, Ajmer, etc. This is obviously where? Part 8. Then Part D, only Andaman Nicobar Islands. Part 9. Sure. This was your original constitution. Indian territories were divided into 4 parts. Obviously, then what happened? Part B, Part D, they deleted by 7th 1956. That's what yesterday we wrote. PS means princely states with legislature. Part C, other princely states plus chief commissioners provinces. Part D, only Andaman Nicobar Islands, ANI. So this is original Part 5, Part 7, Part 6 to 7, 8, 9, all of those ones. Fine. Then related to which ones? Reorganization, linguistic reorganization you can say. Linguistic reorganization. Let's quickly sum up. Dar and JVP committee, both what? Rejected. No current affairs angle in all these things because these are all historical aspects. Dar and JVP committee rejected it. Means linguistic reorganization, they said necessary. Whatever British had done, continue the same. Administrative convenience matters. If you want to mention that word also. Administrative convenience more important. Dar and JP committee rejected linguistic reorganization. Administrative convenience is more important. Fine. So then obviously what happened? The kind of historical angle 1953. Very simple facts. Death of Andhra created out of Madras. Then you had States Reorganization Commission 1953, Fazl Ali plus Panikkar plus Kunzru. Linguistic reorganization accepted, but no one language, one state. Linguistic reorganization accepted, but no one language, one state formula. LR means linguistic reorganization. That was accepted, but it rejected one language, one state formula. No one language, one state. When that's in 1953, States Reorganization Commission. Then they had also mentioned other aspects. Does it other not too much important for prelims? Simple sum up. Linguistic cultural homogeneity. Abolish 4-part classification. For 16 states plus 3 union territories. Fourteen states, 6 union territories. Part 7, Part 9 deleted. Part 7 and Part 9 deleted. Fine, this is your till 1956. Then comes, that's what is the question that asked. Reorganization post 1956. Very simple ones, just quickly sum of facts, concept, everything is not necessary here. Dadra Nagar Haveli acquired by Government of India 1954. So that means acquired territory till 1961. 10th Amendment 1961 made a UT. Goa Daman Diu acquired in 1961. 12th Amendment 1962 made a union territory. Twelfth Amendment 1962 made union territory. Same aspect again with respect to what? There is no amendment here, keep it in mind. That's what was your next question. Discuss in prelims 1. Himachal Pradesh made a state from union territory. MMT. So they asked a question with respect to Tripura, a little detailed. Everything is not necessary with respect to Sikkim. Directly mention. Okay, because if in case they ask like that. Thirty-sixth Amendment 1975, Sikkim made state, 371F added, 2A, 10th schedule, delete. Article 2, capital A and 10th schedule deleted. This is your Sikkim story. So till now they have not asked these kind of ones, but last year, I mean 2025, you had that one question that we'll go through it. Then 1987. Fine. This is broader aspects of your Union and Territories chapter, purely kind of historical aspects. Number of questions are relatively very less. Maybe they would have put it under, I'll just search. Okay, maybe they have not added that question then. This one. Look at this question. It's actually related to Union and Territories, but they are not made purely polity, history kind of an angle, geographic and everything they have tried to merge. Yeah, Arunachal Pradesh. Obviously, what is the capital of Arunachal Pradesh? Itanagar. That's why look at it. The capital is named after a fort. And the state has 2 national parks. See, this is not actually kind of polity. National park, everything is what? Environment, geography, but that's what is inter-subject kind of a link. So obviously Itanagar, Ita means what? If you look at it actually, brick. So they have a very famous fort built using bricks. That's why it is Itanagar. And if you recall, how many state national parks are there in Arunachal? Obviously 2, if you recall which one. One is Namdapa, another one is, I think, Mauling or something they have. So 2 national parks they have. Actually first statement is correct. That's your environment angle, but they have interlinked between the subjects here. The kind of new kind of questions. Nagaland, that directly is your whatever we discussed now. Came into existence on the basis of a Constitutional Amendment Act. Obviously just now we mentioned Nagaland created which year? 1963. Just look at it here. Nagaland, did we mention any constitutional amendment there? So obviously no, because it's related to Article 3. In other words, this statement is what? Second statement. On the basis of a constitutional amendment is wrong. Tripura, initially a Part C state. Yes. So if you recall, because Part C is what? What is Part C? Just we wrote other princely states. Understood? In other words, without legislature plus chief commissioner provinces. That's actually Tripura was other princely state. It was ruled by a king. Understood? So they asked about that. It became a centrally administered territory. Centrally administered territory means what? Union territory. Understood? Yes, it was a union territory. That's what it's a little detailed event. Understood? Three statements they have asked. One is Part C, then union territory, then made state in which year? Obviously which year? 1972. So all three statements they combined. That's what a little in depth they have gone. Understood? So same pattern if they repeat. They ask for whom? They ask for Sikkim. What was it? Till 1974 what was it? Then what was it? So they ask like that. Or Goa they may ask that it was in our, let's say for example, Dadra Nagara Valley, that it was a acquired territory till 1960, from 1954 to 1961. Then it was made a union territory. Now it is merged with which one? The Daman Diu, Dadra Nagar Valley, all of them merged in 2020. So that kind of pattern also they may repeat. Purely factual one, and the two combining with your national park, your capital city, all of this kind of a little geography or an environment angle also. Little tricky. Answer is you have to what? Obviously, second statement is wrong. In other words, answer is only two. Yeah, maybe I think as far as I recall from this chapter, this is the only one. Nari Shakti or all your written. Rest all is, you won't have any direct questions from here. These kind of questions, I'll tell you that. Delimitation that we did yesterday. National flag one that will not repeat. Home guards. Okay, reservations. Scheduled areas. Constitution. I think other than that, as far as I recall also, that's again your prisoner again fundamental rights. I'll clarify that. This is again kind of a history angle. This we discussed. This we discussed. Yeah, there is, I think as far as I recall, there is no other major question on union and territories. Maybe they may ask your kind of chronology, all those ones, that what came first, what came later, all of those will be very easy for you. You can handle that. Schemes, Aadhaar, nothing, Aadhaar again. Other than that, union and territories chapter doesn't matter much first. For us, the most important chapter, I mean one of the most important chapter is which one we have to study, discuss next. We'll directly go to fundamental rights. So many questions are there. Of course, we'll discuss that in detail. Just take a quick 10-minute break and can come back. So we'll continue till as we did yesterday, maybe till 12:15, 12:30 we'll continue. Then we'll come back by 2:30 or 3. This is obviously a very important chapter. I don't even have to tell. So many questions will be there. Okay, let's start with the one of the most important chapters. Actually, you can say the most important chapter in terms of number of questions, though Parliament they ask more. Of course, here so many current affairs. Current affairs is not completely new one, but few one other things. Right to personality, right to be forgotten, all of those things continuously keep getting repeated. So, yeah, just very basics first. Obviously, which one? Yeah. Magna Carta of Indian Constitution. Okay, these are three keywords. Claims of individual against the state. Okay, another one you can write, entitlement of an individual. Of course, lots of types of rights are there, that will come back to that. And then, same way, yeah, so these are other ones. So you can also link to so many other ones. You can also link to which one? Separation of power, constitutionalism. There's so many things you can link. So that is broadly significance of fundamental rights. Fine? Huh? The screen is not working. ಏನಪ್ಪಾ? Upwards. Okay. ROL means rule of law. Okay. 14, 15, 19, 21, 32, basic structure. Huh? 13, correct. Judicial review, correct. You can add 13 also. Correct. 13, 14, 15, 19, 21, 32. So just sum up core features of fundamental rights. Normally, most of the questions, if you observe, they'll ask it till here itself. Rest, normally, rarely they extend, but because one UDHR, they have asked it regularly, so you have to mention that. Quickly, whatever from prelims perspective, types of rights, only core concepts. Natural rights, they have not asked till here, till now in UPSC, I mean prelims. Optionals, that's a different issue. Okay. Right to life, liberty, property. If you want full forms, obviously you'll be knowing UDHR means what? Universal Declaration of Human Rights. That is the most important document with respect to human rights, because based on this they have asked at least 2-3 questions. When we go through PVQ, you will understand. Short. So it includes what? In simple terms, remember, you don't have to go and read what all human rights are mentioned there. Just automatically assume whatever you think is important for a dignified life, everything is important. Everything is mentioned under UDHR. That's why includes all human rights essential for dignity of human being. Anything imagine, education, health, equality, prohibition of discrimination, in anything you imagine, water, sanitation, this, that, jobs, literally everything you have. So you need not go and just, what again by heart there, what are the rights mentioned under UDHR, not necessary. Fine. If you have forgotten those full forms, what do you mean by ICCPR? International, exactly, International Covenant on Civil Political Rights. We'll discuss that. That's your first generation, second generation. At least 3 generations will write. 4th and 5th is not important for us because that's still not clear. Civil Political Rights, ICCPR, International Covenant on Civil Political Rights. Obviously very simple, like what? Right to equality, right to expression, freedom of expression, all of them are just civil. International covenant on, obviously which one? Economic, cultural, social. You can also add cultural if you want. Obviously that means which one? Right to religion, right to education, right to health, right to drinking water, sanitation, environment, all of them. Second generation. Then third generation is what? Group rights. Unsure. Simple examples. UNCRC, UN Convention on Rights of Children, UN Convention on Rights of Persons with Disabilities, UN Convention on Rights of Children, UN Convention on Rights of Persons with Disabilities, UN Convention on Rights of Persons with Disabilities. Fine, fourth and fifth generation are still evolving. Normally we discuss in your normal classes, but that's not necessary. So they can't ask a question on it because it's still not clarified. Another point you have to understand, which is again, you never know if in case they ask. According to UDHR, human rights are, what are universal? First point. 2, inherent, means by birth you will get it. 3, indivisible, means you can't get it in parts, you have to get it as a whole. 4, inalienable, means nobody can take it away from you. According to UDHR, human rights are universal, inherent, indivisible, inalienable. Universal, inherent, indivisible, inalienable. Fine? Yeah, then just that very famous illustration that we keep mentioning. Which one? Broader one. Okay, this is statutory, you can see. Legal rights equals constitutional rights plus statutory rights plus fundamental rights. So legal rights is a broader concept. So which are your constitutional rights? If you want Indian context example, Article 300 capital A, Article 326 right to vote, right to property. Fundamental rights, obvious it is. Yeah, this is what? RTI, right to information, right to education is fundamental right also, right to work, Narega Act, etc. Those are all your statutory. Obviously, as the name says, statutory rights means what then? Given by an act passed by the legislature. Supreme Court clarified. Yes, so many cases they have told that it is statutory rights, some cases they have told it constitutional rights. So actually there is lots of confusion with respect to is right to vote a constitutional or statutory. I think recently again they have told it's a statutory right. Means what? Means in other words, Parliament can through an act, RP Act obviously most importantly, manage the details related to the voting, who can vote, who cannot vote, all those things. That's a famous say they call as statutory rights. Though actually it is constitutional plus statutory. According to Supreme Court it is statutory, but they had already asked the question. So if you recall almost 2016 or 17, right to vote is what kind of right? So UPSC had given it as constitutional right. Though Supreme Court itself had multiple times told that it is statutory right. This is not the first time. Even earlier also Supreme Court has clarified that right to vote is statutory. Statutory means what? Parliament can regulate it through a normal act. But UPSC had given that answer as constitutional right. That it had become a little controversial. But as of today, again, Supreme Court has clarified. Again, as I told so many cases earlier, even now, that right to vote is what? Statutory right. Not a new judgment, but already was there. That they have repeated it again. Okay, fine. So this is broadly the what you call this kind of an basics related to that.
Then comes your which one? Let's start with the first one. Article 12. Another two question. Is judiciary part of state? Obviously answer is what? Yes, it is. According to Supreme Court Ashok Hurra case. Again details are there. Judiciary only with respect to the what do you call this administrative function and not to the judicial function, but that's a little detailed. Judiciary part of state. But remember, judiciary not mentioned in Article 13. Article 12. Who has clarified it? Supreme Court. In other words, implicitly now. Private sector working for state is also part of Article 13. And still a broader definition is there, that's not necessary for us. R.D. Shetty case, all of those things not necessary. For prelims, this is more than enough. Sorry, Article 12. It will become judicial review. Sorry, Article 12. Article 12. 13 is judicial review, that's the next one. Both Article 12. Fine. Yeah, then this is kind of favorite for UPSC also. Next article. There are lots of questions related to that. There are other doctrines also, eclipse also related to it. Once for all doctrines I will sum up at the end. Doctrine of fifth and substance, doctrine of eclipse, doctrine of whatever, so many other colorable legislation, all of those things. In other words, when you say Article 13, that is also about what? Judicial review. But first point is what? Not mentioned implicit basic structure. So obviously what does it say? If you want that any law any law or part of law which violates fundamental right will be declared unconstitutional to that extent. permanent acts, ordinances, delegated or subordinate legislation, non-legislative sources of law like conventions, judicial verdicts. Non-legislative sources of law like conventions, judicial verdicts. Conventions, judicial verdicts. Fine? Yeah, another clarity that personal law is not necessary now. If constitutional amendment violates basic structure, unconstitutional. That is related to your Article 13, law, or judicial review. Then only core points I will write. Citizens plus foreigners. Available against state, available to both. Both means both citizens and foreigners. Available against state, available to both. Fine. Then of course the first concept, equality before law. That's more than enough. Obviously the other 3 points, absence of special privileges, no one is above the law, and everybody subjected to same court in the same court, everybody subjected to the same law in the same court of law. Right, then equal protection of law, USA positive interpretation. That means if you recall again what? Equality of treatment for people under equal circumstances, similar application of the same law for people similarly situated, only likes are treated alike. Those things nobody will ask you, positive, negative. Keep that in mind. Sure. Now linked to that, there is a broader concept called as what? Two concepts. First is class legislation, two keywords. When you say class legislation, what are they? What are they? Discriminatory. Of course, when you say discriminatory, what it does? Violates Article 14. In other words, not allowed. Then another concept, reasonable classification, means different people treated differently. Simple example, reservations. Different people treated differently. Understood? Does not violate Article 14. But what it has to be? Just non-arbitrary it has to be just non-arbitrary, non-discriminatory. Reasonable classification is allowed. Different people treated differently does not violate Article 14, but it has to be just reasonable. Of course, you can add that word also. Reasonable, non-arbitrary, non-discriminatory. Simple, best example is what? Example, reservations. I mean, there are of course cases for it. Cases all is, that's not part of your prelims. Nobody will ask you cases, which case, all those ones. Except if they want to ask, they'll ask some landmark cases, that's it. Fine? Yeah, then related to that concept, rule of law. Part of or in the backdrop of UK common law system. Professor A.V. Dicey. As we have written constitution. And of course, rule of law is what again? Part of basic structure. But again, keep it in mind, rule of law is not mentioned in Article 14, not mentioned in Constitution itself. Rule of law kind of a concept, they are not mentioned in Constitution. Third component not followed in India because we have a written constitution. Arbitrary power, one question is there, we'll solve that. What do you mean by arbitrary power? Misuse of discretionary power. Fine, kind of linked to this, though they don't ask these kind of questions. What is it? Rule by law. In simple terms, it is opposite of rule of law. Violates Article 14. Discriminatory laws like segregation laws of US, apartheid laws of South Africa, discriminatory. I'm sure, obvious, okay, fine, that's it. If you want example, segregation laws of US. If you want other one, also includes different application of same law to different people, or you can say problem is not with the law but with the implementation. Different way of implementation of same law. I'm sure in simple terms, what is it? Show me the man, I'll tell you the law. So it's like that. So depending on who are you, the law may apply to a little differently because of obviously the power imbalances or power balances. That's also rule by law. In simple terms, rule by law is opposite of rule of law. Discriminatory laws like your class legislation not allowed, violates Article 14. Understood? They have still not asked rule by law till now, but rule of law they have asked obviously. So that's your again another one. Of course, anyhow exceptions will write it again. If in case you want, anyhow we'll write it again in your next one. Exceptions to Article 14 directly. First one, the most important one, it's part of your next article, next instance, other chapters also. Of course, kind of in current affairs, one or other way, last year also it was in news. Rather than professional, mention it as official immunity. Immunity means take it as protection. Official immunity is complete, means whatever actions they have taken in their official capacity, nobody can question it. Official immunity is complete. Then with respect to personal immunity, you have to divide that again. Criminal immunity, again complete. And so if you recall, what is the statement? You cannot register any new criminal case against president or governor when they are in office. Whatever old cases are there, those cases cannot continue as long as they are in office. Last year, not last year, probably this year or probably last end 2024 end, West Bengal governor's controversy. Continuously one or other, there was a sexual harassment charge, allegation against the West Bengal governor, but they could not go ahead with it because what president or governor has? Criminal immunity. You cannot register a sexual harassment or dowry or whatever the case against president or governor when they are in office. That's why Supreme Court is re-looking into the overall extent of the protection available. Is it leading to kind of discrimination, I mean special kind of a treatment, all those ones? We have to see, we have to wait until Supreme Court gives a clarity. As of now, criminal immunity is complete. Then civil immunity, with respect to civil cases, what is it? Partial. Because in civil cases, obviously punishment kind of a one is not there. In simple terms, what is it? Greater than or equal to 2 months prior notice. Minimum 2 months prior notice. Minimum 2 months prior notice. That's your personal immunity available for the president and governor with respect to civil aspects, civil cases. Then overall, just to quickly sum up, immunity available to diplomats, ambassadors, foreign sovereigns, staff of, means people working for United Nations, World Bank, WHO, all of them. I'm sure if you want to trace it in simple at the broad one, Vienna Convention on Diplomatic Immunity. Vienna Convention on Diplomatic Immunity. By 1961 to be more precise, that's okay. That's your Article 14 in detailed. Then Article 15. Prohibition of discrimination on, I'll just sum up because they'll not ask you as clause 1, clause 2. Clause 1 is only against state, clause 2 is against both state as well as private individuals. Clause 3, clause 4, clause 5, clause 6 are all exemptions. Just all those one will not matter for us, just clause 6, keep it in mind. Clause 3, clause 4, clause 5 obviously are exceptions, special provisions for women, children, all of those things. Nobody will ask you those statements. Only whatever is necessary for prelims. 15 clause 6, 103rd Amendment 2019, EWS reservation in education. Because in jobs that will fall under your 16. Maximum obviously how much? Up to 10%. 15 clause 6. Right? And that's the only point that you have to remember in Article 15. Then Article 16 again. Equality of opportunity in public employment. The name itself says, that's why public employment means government jobs, that's why it's only against, obviously, only against state. Assured, again only for whom? It's only for Indians. 15 clause, 16 clause 1, clause 2, all those things are not necessary for us. Overall clarify what is a Supreme Court clarification. First point, what is not there? No reservation for, or first point, no reservation in private sector. No reservation in private sector. 2. No reservation for locals. No reservation for locals. That concept is not there. There's so many judgments for it. That's all again mains part. No reservation for locals. Fine, then Article 16 clause 6, same concept. What is it? EWS reservation in, what is this here? Jobs, same, up to 10%. Again same. Which amendment? 103rd Amendment 2019. EWS reservation in jobs up to 10%. No reservation for locals. Fine. Other things obviously will be there. Just to clarify that. Now, which are most important one? because so many clarity are required, kind of current affairs angles are also there. Mandal case, OBC case, whatever you call it as. Even recently also, if you recall, Justice Gavai had made some statements. So in that context, just to clarify, as of today, there is no concept of creamy layer in SC and ST. In reservation promotion, it's there. That will clarify. No creamy layer in SC and ST as of today. The landmark Indira Sani case, 1992. With establish a permanent body that led to what? NCBC Act 1993, that led to what later? 102nd Amendment 2018. That means as of today, NCBC is constitutional body, originally statutory body. Only in appointment, not in promotion. But here so many other points, aspects are also there. Linked to this, for example, if you apply the recent one, which one? Okay, first angle, let's talk about. Because before subcategory identification, first let's talk about it. Because that also they have asked a UPSC question. Identification of SC or ST. Answered. Article 341, Article 342. President has the power to notify the list. President has the power to notify the list. Power to notify the list. Fine. Then what happens? Just to mention, add or delete. Addition or deletion from list. How do you do it? Simple. It's like this. Even if you recall, kind of current affairs angle also in Karnataka continuously it was discussed. State government will forward it to either NCSC or NCST, depending on obviously their own ones. Then it will get forwarded to cabinet. Then it will get forwarded to parliament. Then it will get forwarded to president. Assured. Then clarify. Simple majority. In other words, what is not necessary? No constitutional amendment under Article 368. If you have heard the order, constitutional order SC list, constitutional order ST list, if you want that list. Constitutional order in bracket SC or ST list. So this is the original list. For this list you have to either add or you have to either delete. Of course, you can't delete it. Politically, it's not so easy. You can only add. Constitutional order, SC or ST list. Logically, you think if in case they ask, state government recommendation is binding. Obviously, answer is what? No. Ultimate decision is always who? Parliament. Neither state government's recommendation nor SC/ST in NCSC, NCST recommendation is binding. None of them. If you want, there itself, whatever their recommendations, both not binding. Ultimate decision is with whom? Parliament. Keep that in mind. Ultimate decision is with the Parliament. Fine, this question they have already asked it. Then this they have not asked, but just to mention, with respect to OBC, point is what? Central list, state list, separate. For SC/ST, what is it? Yeah, again for your clarification, SC/ST, only central list. Means only Government of India can maintain. OBC, a state can maintain their own, center can maintain their own. Whatever state declare as OBC will get reservation in state level government jobs, state level education. Whatever center declares, they'll get reservation in central, whatever UPSC, SSC, whatever you call them as. Fine, then another topic. Subcategorization of OBC, again divided, followed in many states, most of states in fact. If you recall, even in Karnataka they do it, Maharashtra they do it, Bihar, most of them do it. Not in center. If you have heard, which commission? Justice Rohini Commission has recommended it. Justice Rohini Commission has recommended it, still not implemented, that's why not yet in the center. Subcategorization of OBC followed in most of our states but not in the center. Justice Rohini Commission has recommended it. That is with respect to subcategorization of OBC. Understood? Now, what you call it as, remember last year's judgment. Subcategorization of SC/ST. Subcategorization of SC/ST. Just to mention, cases are not necessary actually here. Means Supreme Court in Inivi Chennaya case said that SC or ST is a homogeneous category. That's why what is it? No subcategorization, not allowed. Now reverse. Davinder Singh. Again I am telling you, judgment doesn't matter for us. In prelims it doesn't matter. Davinder Singh was the state of Punjab. Opposite term. Heterogeneous, that's why subcategorization allowed. And who can do it? States can only subcategorize. That's why if you have heard in Karnataka, continuously the controversy was going on. States can directly subcategorize, center need not. States can do it on their own. Heterogeneous category, states can subcategorize. In center they are still not practiced it, but in so many states they are trying to. There is subcategorization of SC/ST, which is last year's judgment, Davinder Singh case. Then the legal angle, all of these things, positives, negatives, that's a different issue. Then again another one, reservation in, because this also question UPSC has already asked. Reservation in promotion. Article 16, clause 4A. Only for SC, ST. In other words, not for OBC. So whatever we write now, that UPSC had asked it as a question. M. Nagaraj case. Triple test criteria. First one is what? Quantifiable data should be there. Inadequate representation should be there. Third criteria. This was your prelims question. Don't compromise merit or efficiency of administration. Same point you find it where? Article 335. Of course, these terms what? As I have told you multiple times, even in normal classes, even here keep it in mind. All these key terms, what they don't do? They don't define it. You can't define it. What is merit and efficiency? It's not so easy to define. Don't compromise merit or efficiency of administration. Article 335. The term merit or efficiency is not defined, of course, but it is mentioned in Article 335. On the third statement, you will see those questions that they had asked. Don't compromise the merit or efficiency of administration. Right, that is reservation in promotion. Then same aspect, Jarnail Singh case, creamy layer in SC or ST in promotions. So apply creamy layer, but not in jobs, means not in appointment, where? In promotion. Supreme Court had told that in Jarnail Singh case. Creamy layer for SC or ST, you can say, in promotions. Jarnail Singh case. So the rest all is not allowed, not important. 16 clause 4B, if you recall, what is it? What they call as, what do you call this? What is that keyword? I forgot that keyword. Article 16, you have to, whatever is unfilled vacancies are there, you carry forward. Article 16 clause 4B, carry forward rule in reservations, means if the vacancy is unfilled this year, what do you have to do it? Extend it for next year, continue it. Carry forward rule. Within that, carry forward rule for unfilled vacancies. Carry forward rule for unfilled vacancies. Even in Jarnail Singh, there is something called as what? Consequential. Again, to that extent, nobody will ask you, don't worry in prelims. Consequential seniority in reservation in promotion. What is consequential seniority? Again, it's a little technical one, not necessary. In simple terms, advantage for officers belonging to SC and ST, reservation in promotion. That's it. Consequential seniority in reservation and promotion. But creamy layer you have to apply is what Supreme Court had told in Jarnail Singh versus Lakshmi Gupta case. Right? Then there is concept of horizontal consequential seniority. Yes. Jarnail Singh case, consequential seniority upheld. Jarnail Singh case. That is too much of details related to Article 16, but they have already asked 1 or 2 questions on that. Then 17 more easy, which is what? At least we'll finish till right to equality and try to solve few questions. Other parts we can do it in the afternoon. Abolition of untouchability. First point, against both state plus private. It applies against both state and private individuals. Fine. available to both citizens plus foreigners, or you can eliminate it 15, 16, 19, 29 and 30. You leave out those 5, automatically others are available to both. Then what is it? Absolute means what? No reasonable restrictions. This is the first exception. 23 is largely another exception. Then what is the next one? Term means untouchability, not defined. What exactly is untouchability? We don't know. Broadly, obviously, there is a larger description. Untouchability not defined in constitution. I have already told you multiple times. The logic is most of the keywords, 9 out of 10 times, if in prelims they ask the statement so and so term is defined in the constitution, if in case you are not sure about it, assume it is what? Wrong. In the constitution they don't define terms. Very few terms are defined in article 366. Other than that you don't find any definitions. Very rarely you will find that. I'm sure. So 9 out of 10 times if the statement is so and so term is defined in constitution, take it as wrong. And 9 out of 10 times if they say that so and so term is mentioned in constitution, 9 out of 10 times it is right. Because or at least you would have heard commonly, is it mentioned, is it not mentioned, automatically you will judge that. Define, don't get confused, they don't define. Very rarely they define it. Right? So that is not, other than that you don't have to have, of course there are few acts that all that you will be knowing, SC/ST Atrocities Act, Prevention and Protection of Civil Rights Act, not very important one. Then 18. First directly you mention that Balaji Raghavan case. Yes, Padma awards are not titled under Article 18, but what you should not do? Don't use it as prefix or suffix to your name. Means in front of your name or at the end of your name, you don't have to. Even further, there are detailed rules are there, but that is a broader point. Example titles like Nawab, Nizam, Sir, whatever, all those ones violates equality, kind of promotes monarchy, feudalism, promotes superiority, largely hereditary in nature. That's why it is not allowed. And simple terms, what state cannot give it for what? Anybody. Indian citizens cannot accept from any country. And third, obviously, you know, if in case you are a foreigner working for Government of India, means Office of Profit or Trust, you cannot take any title from any country except the permission of President of India. Same way, if you are an Indian or a foreigner holding an Office of Profit, forget about title, you cannot accept any position or whatever emoluments offered by other government, again same, without permission of President of India. That details they will not ask you, but this is the core that you have to keep it in mind. And so what is title, what is examples, all those ones. This is broadly, again as I told, obviously applicable to what then? Again 18 same, only against the state, because only state can give you titles. Whatever others give, that doesn't matter. Again for whom? Citizen plus foreigner. We will try to go through questions still here, means still article 18. Whatever you okay, so order is a bit changed. Take it as 1, 2, 3. So that they made us 2, 3, 4. I have already told you the logic. It's the question is related to which one? Universal Declaration of Human Rights. And I have already told you the logic. Logic is what? Whatever is important for a basic dignified life for human being, everything is there. Obviously, what is education important or not? That means it is there. Access to public service means what? Whatever service means, you take it as in general services or jobs also you can have it. Right to food, obvious it is. That means automatically answer is what? Yeah, so whatever is important for human being. Minority, we have still not done it, that we'll do it later. 29, 30. Okay, this is not, we'll come back to in judiciary, this one. Okay, exploitation, 23, 24. See this one, right to vote and right to be elected in India is a, unsure. See, actually, so it is a statutory right. So now here you don't have an option, you have to take it as what? Constitutional rights, article 325, 326. Yeah, this is very simple statement. That's it, simple one. In the beginning itself we wrote, they are claims of citizens against state, not state against citizens. Of course, right to privacy you will be knowing, but we'll come back to all of them later. Then this one. If you look at it, obviously which one you have to eliminate? People's responsibility to government, because as I have already told you multiple times, in any democracy, who is responsible or who is answerable to whom? Government is answerable to the people, not the people being answerable to government. Just take that out, automatically answer is there, 1, 2, 4. Okay, that again will come back. Yeah, so broader ways I have tried to link. Again I have told you, interpret UDHR in as broadly the manner as possible. Other than the fundamental rights, which are the following parts reflect the principles and provisions of UDHR? Yeah, always remember UDHR is as broad as possible. So it means one or other way you will find the features or provisions of UDHR where? In preamble, because in preamble you have words like what? Equality, liberty. Of course will come. In DPSP also right to education, right to job kind of things are there. Of course you will get it. In duties also dignity of women, conserve environment, all those things are there. One or other way there is a link. Understood? So that's why broader interpretation you have to do. Okay, this is duties 1, leave that. Duties. Okay, rights and duties. Duties. Again very simple one. Which are the following categories of fundamental rights incorporate? Untouchability as a form of discrimination, obviously which one? Right to equality. Writs will come back to that later. Okay, right to property as of today, we have still not done it, but okay, if in case remember, okay fine, leave it, that will come back to it later. Yeah, this you tell me the answer and you should tell the reason. Go through the question, but you have to tell the reason why. Look at the wordings properly. Unguided, uncontrolled discretionary power. As we already told, arbitrary power means what? Misuse of the discretionary power. That is, in other words, they have used unguided, uncontrolled. In other words, absence of arbitrary power. It is referring to the first point of your rule of law. Rule of law which right under which article? Article 14. Because normally, I mean, to an extent, few students are confused between 14 and 32. Saying that okay, it is about violation of misuse of power, writs and all those things. They are not asking you what will you do. What they are asking here? Which, if in case there is an arbitrary power, which article is violated? They are asking. Violates which one of the following articles? They are not asking you. If in case it is violated, you will get the solution under which article? They are not asking. If the same statement becomes, if in case of uncontrolled discretionary power, one can find their solution. One can find the remedy using which article? Then the answer is what? Yeah, that is the concept of what? They are not asking you how will you find solution. They are asking you what? Which article is violated? Rule of law is violated. Rule of law is part of which article? Article 14. Uncontrolled discretionary power. In other words, arbitrary power. Privacy multiple times, everybody knows. Due process of law, we still not done it. They cancelled the question if you recall. That is first amendment. Back to that. Writ of prohibition. Okay, but few other questions were there. Reservations, probably the merit of administration. Where is that question? Maybe efficiency. Yeah. Go through the question. I've clearly told you the answer. Statement 1, correct, wrong? Correct. Statement 2, wrong. So, because same point, that means answer is very clear. Statement 1 is correct, but yeah, I think another one was identification of SC/ST. Also there was a question actually. What will do that? That's the question. Determination, maybe SC list. Okay, maybe I don't know what exactly means. Who will determine, who will add, or whatever we had mentioned, that who is the ultimate one? Parliament is the ultimate decision maker to add or delete a caste to the SC or ST list. That question was there, but I am not able to, I don't know what exactly words they had used. Maybe one or other way we will find that. So that also that asked. Yes, these are the questions only, the very easy questions only I have got, especially till here. So then in the next session we will discuss upon which one? From article 19. So right to freedom we will discuss. Again, direct questions on that also is relatively less. So fundamental rights, especially they focus on which one? Article 21. Writs they focus a lot. 14. To an extent sometimes minority they ask, sometimes untouchability they will ask. But 14, 19, 21, I mean especially, and then 32. These four they ask a lot. Judicial review was there. One second. There was a question on judicial. Maybe they have put it under judiciary then. Yeah, maybe. Pardoning power, okay. CG reports, yeah. Look at this question. Very simple one. Answer is obviously, Chan. A. Power of the judiciary to pronounce upon the constitutionality of the laws and executive orders. In simple terms, power of the judiciary to question the decisions taken by the legislature and executive. Assured. Second statement, if in case you have a confusion, if in case anybody is thinking about, sir, why not second? Because in second they have used a term. Look at the word. Judiciary cannot question the wisdom. Why did you do it? You don't have to question. What is only judiciary's role? Is it according to the constitution or not? You tell. You can't question them. Why did you do it? Didn't you know that it was wrong? That is not your role. As a passing remarks, they may do it. Wisdom you can't question. I'm sure you did not have the knowledge. Why did you make this law? That's none of the business of judiciary. Just tell, is it according to the constitution or not? Ultra vires or intra vires? Intra vires means what? Constitutional, ultra vires unconstitutional. That's the only role. So power of the judiciary to pronounce upon the constitutionality. There was another one actually, that was a little controversial statement also. Not able to find that. Judicial review. Constitution provides for judicial review, something they had mentioned. Well, that had actually become controversial, that's why. Okay, so they have mentioned it here. Okay, just go through it. If in Bharat Ratna award kind of that they had asked. Yeah, not as a fundamental right one, but how many awards are given, something like that they had asked. Yeah. So go through this, because second statement was a little controversial. Thus I'll just clarify that. If in case you get that kind of questions, be a little cautious next time. Constitution defines basic structure in terms of federalism, secularism, rights, democracy. Answer is what? First of all, basic logic I have already told you. If they mention define, take it as what? Wrong. But more basic points, what is it? In the constitution, what itself is not there? Basic structure concept itself is not there. It's a judicial innovation in Keshwananda Bharati case. So concept itself is not there. Even if you didn't know that, obviously we'll discuss that when we discuss basic structure. Define word is there, just take it as wrong. 9 out of 10 times. I can't tell you every time. But if in case you are not sure, I'd look at that defined word, take it as wrong. But look at second statement, what it says. Constitution provides for judicial review to safeguard the citizens' liberties and preserve the ideals on which constitution is based. Answer is what? If you look at the wordings, actually answer is yes. But what UPSC has done? UPSC has taken the term provides as mentions. Now read the statement. In place of provide, take it as mention. Constitution of India mentions judicial review. Answer is what? No, because judicial review is what? It is not explicit, it is implicit. So UPSC has interpreted the term provide as judicial review, provide as mention. Unsure. But broadly if you take it, answer side, actually statement is correct. But they interpret it as mention, they took it as wrong. So that's a little, what do you call this, kind of a tricky one. So in other words, keep it in mind. Next time if you find the term provides, largely interpret it as what? Mention. Unsure. So please write that somewhere in the margins. The term provides means mentions. Or exactly copy the statement if you want. Because you may forget that what is this provides means mention later. So for your clarity, please mention 2020 judicial review question. So that when you, at least you have that, you can go back to your this PYQs, that time you will get better idea when you will be revising these notes in your maybe March, April, that time. 2020 question judicial review statement. So they have taken it as wrong only because the term mentioned is provides. Or else actually if you read it, its actually statement is very, very valid. Fine. Okay. So other things we'll take care of it in the afternoon one. So as per, we'll try to at least finish fundamental rights first, because if fundamental rights is done, so then tomorrow we can take care of DPSP, fundamental duties, amendment of constitution, all those things quickly we can finish up, judiciary, everything. So at least fundamental rights we have to finish it. Fine. Okay. We'll come back in the afternoon. Maybe made us same 3 to 5:30. Sure, because few people have your optionals by 6. So without break, we'll try to finish it by 5:30. We'll see. Fine. Yeah, come back by 3. Same here itself.